everyone, it has been a long time since I have uploaded a video, but today I want to discuss about what is law and whether law is necessary. This is part of the legal methods curriculum under the various universities in India. So here is the agenda. Today we will be discussing about what is law, then definition of law, and then is law necessary or not, and then the functions of law and sources of law. Before we understand law in legal parlance, let us understand law in general parlance. Law is nothing but set of rules and regulations which help in regulating human conduct. Law is similar to justice, morality, and reason. Let us suppose that there are two children who are fighting over a chocolate. Here, justice will pitch in and say which of them deserves to eat the chocolate based on the arguments, and as well as evidence. Let us suppose that you are staying in a locality and there is a public notice which states that you should not litter. You are following that rule because it talks to your morality, and you are following it because you want to be a citizen who is full of civic sense. And you are doing it not because of fear of security agency, but because your own morality says this is the right way in which one has to lead life. That is nothing but morality. Let us suppose that you are going on a two-wheeler and you see the red signal and you stop. You are stopping here because there is a reason associated. That is to make sure that accidents do not happen. You have a power of reasoning in your mind, and that is why you can always think which is right and which is wrong. Law includes statutes, legislations, and precedents. Under Article 13, Clause 3, Subclause A of Indian Constitution, law includes any ordinance, rule, bylaw, order, regulation, notification, custom, etc., which have the force in the territory of India. And in the point of view of judges, law can include decree, order, and judgment. Let us suppose that you are writing an exam, and after you write the exam, that is similar to judgment. The answer script you write is nothing but the judgment. You will give reasons and answer each and every question according to your level of preparation and everything. So in a judgment, if you see, there will be facts, then there will be issues, and each issue will be opined based on the evidence, and the point of view of laws will be taken into consideration, and everything will be taken into consideration, and then they will come up with something called as a judgment. Okay, so judgment is similar to you writing the exam, and you will be writing the exam based on the questions asked, and you will reason out why you think this is the right answer in your script as well. Okay, so that is nothing but judgment. Okay, and then here, after you write the exam, the evaluator will evaluate your script, and he will say the reasons as to why you have to be passed in the exam. That is similar to order. So order will give out the reasons as to why a person has to be given a following relief. And decree is nothing but the thing which will state whether a person has passed in the exam or has failed in the exam. So it is giving out the ultimate result of whatever you have actually pleaded. Okay, so this is nothing but order, decree, and judgment. You will learn this in your CPC, but for the time being, understand it using this simple illustration. Before we go into the various definitions of law, we have to understand the various schools of law. The first one is natural school. Okay, so here let me give you an illustration. Let us suppose that you are eating an apple. So after you eat the apple, you can gauge whether it is sweet or not, whether it is ripe or not, right? So here the natural school will say that a person will follow the law because he has the ability to reason out. Okay, and He is following the law because it is from the gods that the law has emanated. Okay, so this is nothing but what the natural school jurists say. Okay, and we have the analytical school that is also called as positivist school. So the positivists believe that law was not of a divine origin, but law is something which the men do. Okay, it is man-made. Okay, so here you have to know that under analytical school, people follow the law because it is the sovereign who is issuing the law. So in the illustration that I gave regarding the apple, the analytical school is not concerned about how ripe the orange or apple is. It is concerned about who is issuing you the command to eat the apple. Okay? You are following the instructions given by a superior, and you are that's why following the law. So that is what the analytical school will actually say. You are following the law because the sovereign is issuing the command. Okay, and after you follow the law, you have something called as sanction. Okay, the sanction can be the reward as well as the punishment. If you follow the rules, let us suppose there is a traffic rule which says that you should not drink and drive. If you don't drink and drive, you will be rewarded. Okay, and if you obey the rule, then you will be rewarded, as I told you earlier. If you don't obey the rule, you will be given punishment. Okay, so that is nothing but law emanating from the sovereign, which is backed by threat of sanction. That is what Austin has told. Here you have to understand that we had something called as slavery. Okay, so here in the analytical school, the jurists say that is right. Whatever is happening, whatever is the slavery laws, those are right because they are originating from the sovereign. Here, the person is not using the power of reasoning, the power to understand which is right or wrong. Here, he is following the law because he knows that if he doesn't follow the law, he will be forced to go through imprisonment. And it is the sovereign who is issuing the command. In the sociological school, law is considered to be a way in which societies are studied as a whole and not individually. Okay, man is a social animal. We all know how the society has evolved. So first we were individuals, then we were families, then we became tribes, and then clans, and then that led to the culmination of kingdoms, and kingdoms later on culminated into empires. Okay, so this is the way in which the society evolved, and after the empires came constitutional monarchy, and later on democracy. Okay, this is the way in which the society has evolved. So the sociological school will look into the man as a social animal, and it will look into law as a way in which social engineering is administered in the society. Okay, so Roscoe Pound was one of the key jurists under the sociological school who says that law is a tool for social engineering. And then we have the historical school. Under historical school, there is a person called as Savine. He says that law is like a language. It keeps on growing. Okay. And he also talks about historical consciousness of people. Okay. And it is the people themselves who have given the laws to themselves. And that is why they are following the law. Okay. So the law is something which is a product of traditions, history, and all these things. That is what the historical school will actually say. Here, Sevani has used the term Volksgeist. It is spelled as Volkgeist. Okay, Volksgeist. It has to be pronounced as Volksgeist. Okay, it is something which can be translated into will of the people. Okay, folks means people. Okay, and geist means will of the people. So it is the historical consciousness that is being reflected in the law. Okay, and see here you have to understand that law should always be codified only when it reaches a civilized state. Until then, laws should not be codified. Today we have a written constitution, but in the UK it is the unwritten constitution. So they don't want to uh, write the laws or anything and come up with a constitution, because constitution goes through a lot of amendments. They want to save the time, and the way in which the British Parliament or constitution came into existence, the circumstances are very different. That is why their constitution should not be compared with ours. Our culture is made up of lot of religions, lot of ethnicities, and lot of other challenges, and that is why we need a written constitution. Okay. Now we'll come to the next school. It is the realistic school. Okay. So realistic school think that law is something which the judges do and not what the statutes make it to be. Okay. So that is true, right? Today we all know the Vishaka guidelines. So when Vishaka guidelines originated, it was not the parliament which made the law. It was the judiciary which came up with the Vishaka guidelines to protect the women from sexual harassment at workplace. So you can see that to make sure that the justice reaches the vulnerable, we have the judiciary pitching in and coming up with a lawmaking power, which is inherent in the judiciary itself. Let me summarize the sub-schools and their definitions of law. So the analytical school says that law is the command of the sovereign backed by threat of sanction. And the natural school thinks that law is valid only if it conforms to justice, reason, and morality. And historical school thinks that law grows from historical consciousness of people. And sociological school thinks that law is a tool of social engineering aimed at social welfare. So let me make you understand what is exactly social welfare. A society where there is no discrimination based on caste, religion, gender, etc. So we all know that India is made up of various castes, religions, etc. So here social welfare will look beyond the castes, gender, religion, etc. to make sure that everyone is treated equally before the law. Now we have the realistic school. Realistic school thinks that law is what the courts do. We know the basic structure doctrine, right, which originated from the Keshavanand Bharti case. So basic structure doctrine indirectly led to a law being interpreted and culminated into the practice of constitution. They emanated from the judiciary. See, we have the concept called as separation of powers, but you have to know that the lawmaking process is very time consuming. So that is why sometimes the judiciary ends up making laws so that it reaches the vulnerable. Let us look into the various functions of law. So Plato here says that law is something which is regulating the human conduct. And if a person doesn't follow the law, he is nothing but a brutish beast. Do you agree with the statement? And Thomas Hobbes says that law was something which restricted liberty, and liberty should also be exercised in such a way that it should not harm the other person. Let us suppose that you are a music lover. Okay, so you should not listen to music in such a way that it causes nuisance to the people living around you, right? So you should exercise liberty in a limited sense and within the constitutional ambit. Otherwise, it will lead to a public nuisance. John Locke. Let us understand his perception of law. He thinks that law was something which taught restraint to people. Okay. And it was something which helped them preserve and enlarge liberty or freedom. Okay. Liberty, freedom, fraternity, all these are rods to measure democracy. So a democratic country is some evaluated based on how much of liberty they follow, how much of freedom they give, and stuffs like that. See, we have to know that if a country gives too much of liberty to somebody, it may end up like Bangladesh, Nepal, Sri Lanka, etc. So people should not be given the power. Even if they are given the power, they should use the power in the right way. Okay, that is what I believe. Okay, they should not be a state which leads to mobocracy, or they should not be a state where people gather up and overthrow the government, and all these things should not happen. Okay, because we live in a democracy, we live in a civilized state, and all these things. So if there is a rebellion, insurgency, or some resurgency or something like that in the country, then that is something which will lead to nuisance. It will lead to loss of life. There will be a lot of vagrancies associated with it. So that is why we should not make a country have a lot of liberty. Now we'll talk about Roscoe Pound. So Roscoe Pound gives four functions of law. Okay, first one is that it maintains law and order in the society. Yes, and it also maintains the status quo in the society. Correct. See, let us suppose that you and your friend are neighbors. Okay, and you have a wall which is separating both the houses. So let us suppose that your friend is about to build something above the wall. Okay, they want to, let us suppose, uh, demolish the wall, and they want to convert it into their own part of land. Okay, so that is what your friend is trying to do. So to stop your friend from doing it, you have to obtain an injunction. Okay, so the point of getting an injunction is to maintain status quo in the society. You are stopping your friend from constructing such things. Okay. Next is to ensure maximum freedom of individuals. Okay. So your maximum freedom of individual, here you have to understand that maximum freedom can be given to a person, but that freedom should not be misused. Okay. So here you have to understand that what is exactly maximum here. What does Roscoe Pound mean when he says maximum? Okay, a person cannot be given maximum freedom. That is why today around the world a lot of societies are collapsing, because people are given maximum freedom, but it should not be in such a way that people should be their liberty should be curtailed, like how it is happening in North Korea. That should not be the situation. So everything should be midway. Okay, people should be given a right to freedom of speech and expression. Everything should be there, but it is within the constitutional ambit that it should happen. Okay, and next one is to satisfy the basic needs of people. You agree? Let us look into the functions of law in the contemporary world. So law is a device for social control. Social control can be exercised in formal way as well as formal way. Formal way can be exercised only through the help of security agencies such as police, then judiciary, etc. Informal social control are the divine laws. So we all know that there is a custom in India which states that a man should remove his upper garment before he enters the temple. Okay, these are the divine laws. See, that, they do that to make sure that a person remains humble and he respects the deity, and he also shows devotion towards the deity. And that is why these laws are actually there in India. So these are a part of divine laws. Here there is no involvement of security agencies, but we follow the nevertheless. Okay. And then we have the dispute settlement. The law today is a means through which disputes are being settled. So the two ways in which disputes can be settled in India is through going through litigation or going through alternative dispute resolution. Under alternative dispute resolution, we have the arbitration, then we have the mediation, and then we have conciliation. Okay. So arbitrator is nothing but a private court judge. Okay. But you have to know that a civil case will go through a lot of adjournments and all these things. So if you file a civil case today, it may take you at least 2 years to get the relief. But in arbitration, the limitation period is 1 year. Within 1 year, you will be given a relief. Okay. So you should know that arbitration is a time bound process. Okay. And then we have mediation. So the aim of mediation is to meet midway, no matter what. Okay. So you imagine an iceberg. Okay. We have the tip and the base. So we have to reach the midway of the iceberg when it comes to mediation. That is what mediation tries to do. Okay. And then so law is a means through which there is social change. We all know that sati was practiced, then it was abolished, and we have bonded labor, we that got abolished later on. So there are a lot of changes going on. So law is a device through which social changes should actually take place. So the way in which we go forward with social change is to bring forward amendments, legislations, and all these things. Okay. Now we'll discuss about why law is necessary. See, I'll give you an analogy. Okay. Let us suppose that you are going on a car, okay, and you see no traffic police, okay. So that is why there is a lot of chaos as to who should go first and who should go next and all these things. Okay. So what you do is you, out of Samaritan grounds, go out of the car and you start directing the vehicles to come or not come, or to go this way or that way. So you will do that. So you are doing it as a Samaritan. Now, the point is, what is the point of having police when a normal man and a Samaritan can actually do that, right? So, do we really need law today and the various security agencies to make sure that the law is being followed in India? Do let me know in the comments, okay? So, according to me, law is needed for us to teach us what is wrong and what is right, okay? Law is also needed for us to understand that a lot of us come from different backgrounds, right? And to make sure that our backgrounds are taken into consideration while we seek for any relief or adjudication or anything as such. Okay? Especially when it comes to criminal matters. So we all know that nobody is born criminal. They become criminals. Okay. So they become criminals because of circumstances or their cultural background or something like that. We have the various theories of punishment such as retributive theory, deterrent theory, preventive theory, and then we have the expiatory theory, and then we have the reformative theory. So reformative theory says that a criminal has to be reformed to become better citizens in the society. But see, it is always stated that habitual offenders should actually be tried separately and not under the present BNS. Okay, because they do it out of habit. See, a person who has the habit of stealing, they will start by stealing pens, then they start by stealing money, then they'll start by stealing mobiles, and they keep on stealing because that is a habit that they create, and their mind will not cooperate and they do it out of habit and habitual response. Okay. So to stop that, a person has to go through treatment and all these things. So today treatments have become very expensive, so a lot of people cannot go forward and seek remedy or redressal, right? So that is why we have to curb the habitual acts that we do through consciousness. Okay, we should be conscious individuals. We have an ability to understand what is right and what is wrong. Okay, so if something is wrong, we should not do that at all. Next, so law is needed to make sure that there are reforms in the society. Like I told you in the previous slide, we had the Sati Act, Sati system, I mean, okay, and then we came up with the Sati Abolition Act, okay, and then we had Child Marriage Act, okay, and then we had the Child Marriage Restraint Act being enacted, and then we had dowry system. We have a Dowry Prohibition Act. So slowly the world is changing. So to keep up with the dynamic world, law has to keep on changing. So law is a way in which there are reforms happening in the country and the society. This is a continuation to the previous slide. So man can attain a truly human condition given the existence or non-existence of law. Do you agree with this statement? Do let me know in the comments. Okay. So the law hunts for what is good and what is bad. Okay. It is amalgamation of good and bad impulses constantly in conflict. Okay. So we all know that we have two wolves inside us. One is a good wolf and the one is a bad wolf. So it is up to you to make use of the appropriate wolf at an appropriate stage in your life. I'm not saying you should be too good in the society, but you should be in such a way that you should at least be a good human. If not a very good human, but a good human. Okay? And then see, we need law to help us understand what will be the consequences if somebody chooses the wrong path. Okay? So we all know there are punishments associated with it. Okay. So we can also understand law from the point of view of victims. Okay. How do they presume law to be? For example, acid victims today feel that whatever is the punishment that is being given to the accused, that is not enough. Okay. So law should actually consider each and every person, and then law should actually be implemented and acts should be made into existence. So we have the anti-hate speech law in Karnataka. So what do you think about that law? Okay. So where should one draw the line when it comes to exercising right to freedom of speech and expression? So law is something which is teaching us restraint, restraints within the ambit of constitution. So liberty should be within the ambits of constitution, and restraint should not be in such a way that you're subdued totally. That should not be the way in which you have to interpret restraint. Okay, it should mean in such a way that it should not harm the other person, and it should not actually cause subjugation of yourself and your voices completely. Now we'll discuss the various sources of law. Okay, so Salmon gives two classifications of sources of law. One is formal sources and material sources. Okay, so a formal source is nothing but that from which rule of law derives its force and validity. Okay, so here the formal source of law is the will of the state. Okay, so it is the will of the state that is being reflected in the law. Okay, And material sources. See, in under the Hindu law, we have the various sources of law, such as Shruti, Smriti, and then we have the Dharma Shastras, Dharma Sutras, and then we have the customs, and then we have the secondary sources such as legislation, precedents, justice, equity, and good conscience, and all these things. So, what material sources actually say is they are the primary sources of law. See, law was always something which was remembered first and then it was written. Okay, that is why Smritis came into existence first and then Shrutis. Okay, so Smriti is nothing but something which is remembered and then it is something which is followed by people. Okay, and Shruti is something which is written. Okay, so now we'll come to the various sources of law. The first one is custom, then it is the judicial precedent and legislations and values. Today we will focus on only customs and judicial decisions. Okay, and legislation I will deal in the next lecture. So what do you understand by custom? Custom is nothing but a long established practice or unwritten rule having acquired binding or obligatory character. Okay. So that is nothing but a custom. Okay. So you have to understand that what is exactly a binding custom. Okay. So we all know that we have a right wherein the women in the family should be looked after by the men. Okay. A man has to provide for the woman. Okay. That is why we have the maintenance laws, and maintenance favors women because women are considered to be vulnerable no matter what. They will be judged by the society and all these things are there. And today also, if a woman seeks the relief of maintenance, she will be awarded some maintenance, if not anything. Okay. So yeah, that is something which is a custom that we have followed. So that is having a binding effect. Okay. Now we'll talk about obligatory customs. So I told you, know, what are the obligatory customs that we have? Like I told you, know, in the various temples around India, we remove the upper garment and then enter the temple. I mean the men. Okay, they remove the upper garment because that is considered to be a sign of humility, respect, and devotion. Okay, so we follow it as an obligation. It is not binding, but it is obligatory in nature. So Austin doesn't consider law to be the same as custom, and he says that custom is not a part of law because it was not something which is originating from the will of the sovereign. It is the will of people that is getting reflected in the custom. Okay, it is not the sovereign. But here you have to understand that if there were no people, there would not be any sovereign at all. So it works two ways. Customs are divided into two classes, customs without sanction and customs with sanction. Okay. So customs without sanction are non-obligatory in nature and are followed because of public opinion. Okay. And customs with sanction. These customs are binding in nature and are enforceable by the state. See, in the Ayyappa Swami temple, that is the Shabrimala temples, women who are menstruating, they are not allowed inside the temple. So that is a custom that has been followed since ages. Okay, and it is nothing but an essential religious practice of a minority community in India. Okay, and we all know the system such as Good Swami and Kanni Swamis and all these things. So a Good Swami teaches the Kanni Swamis how to live life without using the opiates, then alcohol, and without having any distractions or anything. Their focus should be only on the deity, that is the Ayyappa Swami. Okay, that is the main aim of Ayyappa Swami temples and Shabrimala especially. Let us look into customs with sanction a little more deeper. So what is exactly legal custom? So we have a custom of going forward with Saptapadi during the marriage. So if Saptapadi is not followed, then a marriage will be considered invalid today in India. Okay? But when we talk about these registration marriages and all these things, they do not follow any rituals when it comes to marriage. So should we recognize registration based marriages or not? But the courts have opined that Saptapadi should be there when it comes to a valid marriage. See, up until we go forward before the court seeking relief of maintenance or divorce or anything as such, the validity of marriage will never be challenged. Only when we go forward and ask for a relief will the validity of marriage be checked. That is when such judgments will actually emerge, saying that when it comes to marriage, there should be performance of Saptapadi and all these rituals. And then we have the local customs. Like I told you, Ayyappa Swami temple and its customs are prevalent only in the particular state or locality. It is not followed throughout the India. Okay. And then we have the conventional customs. Okay. What are conventional customs? These are something related to agreements. Okay. So let us suppose that we take the example of uh, Nepal. So Nepal is a country which is dependent on gambling for income. Okay. And it also depends on tobacco, lease, exports and imports and all these things. And that is how the country is actually running. So there they have a custom where they go forward and allow gambling and all these things. But in India, we don't allow gambling. We all know wagering agreements are void. So that is under Section 30 of Indian Contract Act. So if we go forward and do a contract for gambling and all these things, they will not hold the test of time and they will be considered as void and you cannot seek any relief. Okay, so this is an example for conventional custom. So what may be a custom to one society may not be a custom to the other. Now we will discuss about the essentials of a valid custom. The first one is antiquity. So we have the system where the men in the society have to remove the upper garment before they enter the temple. So that is followed in South India. So here, this custom has been followed in antiquity, meaning from ages we have followed it. And it is a practice which is continuous in nature. If we take the history of the temple and everything into consideration, that is a custom which the temple has followed since ages and it is nowhere got discontinuous. Okay, that is why we have that custom prevalent in many of the South Indian temples, and this custom is exercised as a matter of right. Okay, and then it is also reasonable. Okay, it is reasonable because I told you it is a sign of humility, respect and devotion towards the deity. Okay, and we do it out of morality as well. Morality says this is the right way we have to live in the society, and that is why we follow the custom that we have to remove the upper garment before entering the temple. Okay, but there are other temples where a man need not remove the upper garment or something like that. And then this custom should not be opposed or contrary to public policy. Like I told the custom I told you where gambling is allowed, that is Nepal. Okay, but that is not allowed in India. So if we follow the custom of allowing gambling in India, it will be opposed to public policy. Okay, so that is why we don't allow wagering agreements in India. Before we go forward with precedent as a source of law, I just wanted to ask you, do you think gambling should be legalized in India? Do let me know in the comments. Now let us discuss about precedent as a source of law. It is precedent, not president. Okay, please note the difference. So precedent is nothing but judge made laws. Okay. So it is the judges who make the law. Okay. So here under precedent you have to know obiter dicta as well as ratio decidendi. Okay. So ratio decidendi is nothing but the binding rule that emanates from the judgment. For example, if we take the Navtej Singh Johar case into consideration, it stated that consensual homosexual relationships have been decriminalized in India. So that is something which is the ratio decidendi. So this ratio has to be followed in all the cases where there are homosexual couples involved in various parts of India and various courts. Okay. So whatever is emanating from the Supreme Court, that has to be followed by the high courts. And we have the obiter dicta. Obiter dicta is nothing but the opinion of the judges. They have persuasive value but not binding value. Okay. We have the various theories of precedent. The first one is declaratory theory, which says that judges do not make the law but only declare it. Okay. So here you have to understand that this theory takes in the separation of powers concept very seriously. So separation of powers was something which was suggested by Montesquieu. So he stated that all the three organs of the government should function in their independent spheres and there should not be overlap of functions among them. But in India, we follow something called as separation of functions rather than separation of power because power is an abstract notion. Okay. And we all know that absolute power corrupts absolutely. And then we have the second theory, that is the authoritative theory. Courts do more than just declaring laws here. So that is how we have the various judgments such as the Keshavanand Bharti case and then the Vishaka versus State of Rajasthan case and all these things. This indirectly led to a law being implemented in India. Okay. It is not the parliament which is making the law, but the judiciary. We all know that the law making process is very time consuming, and that is why sometimes judiciary ends up making the law. Okay. You know, when we interpret the law, it is automatic that we end up making the law. So it is something which is naturally happening. Okay. Let us now discuss the advantages of sources of law. The first one is that it is an evidence for the existence of customs. So we all know the doctrine of lapse, right? Where the adopted children could not contest to the throne, and that kingdom would become a part of the British through the concepts such as annexation. Okay, so here there is a case law called as R versus Muthu Ramalingam, wherein it was stated that in the Dravida school there was a custom which allowed women to adopt children, and adoption could happen because of the consent of the co-parceners. So what is exactly a co-parcenary property? If a property has devolved from the son by the father, grandfather and great grandfather. Okay, so it should have passed through 3 generations. That is, a property will become co-parcenary property. Okay, so here you have to know that sources of law bring certainty, flexibility and practicality. Okay, and it saves the time of the courts because there will be similar matters which come before the court, and the precedents will help in rendering justice to the people, and it will help as a guiding force in eliminating errors in the future decisions. There is something called as prospective overruling. Here what will happen is the judges will acknowledge that whatever is the decision that had appeared before, that was wrong. So they prospectively overrule the judgment. Okay. So that is also a part of precedents itself. The precedents which emanate from the Supreme Court, that is the Aravali Range case that originated. Here people wanted the Supreme Court to review the judgment. Later on, the Supreme Court took back its, classified definition of, Arabali range. Okay. So you can see that prospective overruling can eliminate a lot of errors in decisions. So what are the disadvantages of having sources of law? So the ambit in which the judiciary operates will get limited. It will look into only customs as sources of law. It will look into only precedents as sources of law and legislations as sources of law and all these things. But it will nevertheless overlook other things which can also be classified as sources of law. Okay. Then you have to know that sources of law, especially precedents, are based on certain incidents. So you have to know that there can only be similar matters, but not same matters. So how far is it good that in a matter that is A, if there is a judgment, how far will it actually be viable to interpret and implement the same ratio that is emanating from one judgment to the other, given the facts are different? And then there can be a lot of erroneous decisions given by the Supreme Court. Okay, we have to be constructively critical about the judgments that are coming from the apex court of the country. Thank you for listening to my lecture on what is law necessary, and the sources of law. Do let me know the answers to the questions asked in this lecture. Thank you. And if you have any doubts, do let me know in the comments.